Hey everyone, welcome. Welcome to Saturday night. Thanks for being flexible. I appreciate it and I appreciate you all being here on Saturday. Just to give you a little, fill you in a little bit on the reason I was gone. My husband Carl is retired from the Air Force. He is a retired military aviator, flew F-4s during the Southeast Asia conflict. And one of his really dear friends, someone who he was very routinely crewed with, passed away a month or so ago. And we drove from Boise to Portland, Oregon to go to his memorial service, which was lovely. He had a service with full military honors, which is incredibly moving for anybody who's been involved in the military. As you all know, I retired with 20 years of combined active and reserve service from the Air Force. My husband retired at the rank of lieutenant colonel with 28 total years of service. So we're a big military family, and it was important for us to be there to see a lot of old friends and to be there to honor our good friend Ray. So thanks y'all for being flexible. We drove back. It's about a 6.5 hour drive, and we got back this afternoon. And so I appreciate you all being flexible and being here on a Saturday to pick up with all of the stuff we didn't get to talk about yesterday. We have a bit to talk about sort of in general. We have a little bit of Murdaugh, we have a little bit of Kohberger, a little bit of Vallow. So just sort of maybe start off with Kohberger. Brian Kohberger is the defendant in the University of Idaho college murder cases. He's been in jail now about 6 weeks, I think, maybe 8 weeks. And his preliminary hearing is coming up the 21st of June. So just to sort of review for those of you that might be a little bit rusty on the procedures that happen for sorry tonight, I'm kind of tired, so there may be more ums than normal. Just a little bit of a review. What happens when someone is charged with a felony, their case either has to be presented to the court in a preliminary hearing or to a grand jury. In either case, either the grand jury or the judge, as the finder of fact, determines whether or not there's sufficient evidence to hold that person over for trial, to bind them over for trial. So my cats were very happy to see me, and I have one talking in the background. So if you hear a cat, that's I have one who's having a little Siamese chat in the background. Anyway, the alternative is either to present that information to a grand jury or to present it to a judge and to have a judge determine. Either way, a finder of fact has to determine whether or not there's sufficient evidence to bind the defendant over for trial. So Brian Kohberger has been charged on what's called a DA's information, which is a preliminary charging document. And he's being held. The reason he's being held in court is because he has not been able to post bail. I believe bail has been set for him, but I could be wrong about that. Anyway, he's being held until his preliminary hearing in June. The court held a hearing. There was a lot of discussion about whether or not his attorney, Ann Taylor, had a conflict or not, because she was listed as the attorney in several cases representing Xana Kernodle's mother, Kara. As it turns out, she had never met Xana's mother, Kara. She had been assigned because she is the chief public defender for that judicial district. And oftentimes her name is listed in the court database, even though she is not actually the assigned attorney. So the court held a hearing in chambers and determined that Ms. Taylor did not have a conflict. Just last week, she filed a motion to appoint an additional co-counsel, and the judge approved that. So she now has co-counsel, but I'm not sure of the name of that person. I didn't dig that deep into it. Haven't gotten that deeply into it. So he's waiting for his preliminary hearing. There is a lot of stuff going around on the internet, and I want to caution all of you. Please, please make sure that before you retweet, retransmit information about the case, that you're sure you're getting it from a reliable source, because there's an awful lot of stuff going on out there right now, and a lot of it is not true. So let's just talk really quickly about what is true and what is going on. Law enforcement has sent out over the period of time since before he was arrested, when they began, since the murders occurred, up until today, they have been sending out, serving search warrants and sending out subpoenas and sending out warrants to collect information. For example, they have sent search warrants out to every one of the potential cell phone carriers out there. Not necessarily because they're sure these people had cell phones through that carrier, but just out of an abundance of caution, they are sending out those warrants. Same with banks. They have papered all the local banks and sent search warrants to them, making sure that they are getting all the financial information from anybody relevant. They have sent search warrants out to Amazon, Etsy, eBay, and a host of others. And the purpose of that is to rule out many of those things. We did hear that we saw the search warrant return from the home in Pennsylvania where he was staying with his parents. And we did see that search warrant return, there were a number of things that were seized: dark clothing, gloves, a couple of knives. We have no idea whether or not any of those things were related or associated with the crimes. No way to know. Those things have been sent to the Idaho Criminal Crime Lab for processing, and we may hear about some of those results during the preliminary hearing in June. But please do not jump to any kind of conclusions based on those warrants and based on those search warrant returns, because we don't have any way of knowing whether any of the things they seized are remotely relevant. We don't have any way of knowing whether any of those search warrants are relevant to where the knife came from. We don't know any of those things. Remember that law enforcement is really just, think of it as a shotgun blast. So all those little BBs come out and they spread out as they're shot. And that is exactly what they're doing. They are trying to cast this really wide net and to pull in all of the information they can in order to maybe find that needle in a haystack. So I don't think we're going to hear an awful lot about Bryan Kohberger until June, but we've got a lot of other stuff coming up that we're going to be really interested in, one of which is the Vallow day bail case, because Lori Vallow, her case, her trial is set to begin on April 3rd. And it appears that they're going to start doing jury selection the week before. So that's super exciting. And we're going to talk more about the Vallow case and the things that have been filed in that case. But we've got a lot coming up to keep us busy. So we don't necessarily need to be out there speculating or passing on misinformation in the Kohberger case. We're going to get information in that case, and it's going to come out given time, but we're going to be patient about that because we're not going to buy into that frenzy that happens when there's a vacuum of information. See, this is the problem. And it's been the problem in the Vallow case as well. When there isn't any information, misinformation floods in to fill up that vacuum. So none of us want to be guilty of that. And I know you don't want to. I don't want to. We're not going to go there. So Murdaugh. We know that Alec Murdaugh has been sentenced to 2 life sentences. He is currently, I can't remember the name of the prison. Gigi knows that. And he is currently there. Anytime anyone is sentenced to prison, particularly when it is their first time to prison, they go through an orientation and a testing phase to determine where they're going to be placed, what their medical and mental health and educational needs are going to be. There's a lot that goes into them to determining placement. We understand Kirkland. Thank you, Denise. I wanted to say Kirkwood, and I didn't think that was right. He is at Kirkland. And so there's a lot that goes into that evaluation process. And once that's done, then they'll determine which of the correctional institutions that he'll be going to there in South Carolina. Most states have more than one correctional facility. And so it'll just be a matter of finding the best program for him. For example, Josh Duggar, who we know is in prison on sex crimes, has been placed in a facility where they have a treatment program particularly for those offenders. And so it is, think of it sort of as if you were starting in college and they wanted you to take placement tests. That's kind of the way it is. So they'll determine where the most appropriate place is for him, and he will get placed into his permanent home. The other thing that's been incredibly troubling is the fact that some faction that could be considered media, I hesitate to call these people media because I think they are irresponsible and probably not really what we would think of as media, but people who are hounding Buster Murdaugh and his girlfriend. And it's just unforgivable. I mean, regardless of what you think about the Murdaugh family and the dynasty that was the Murdaughs, Buster Murdaugh is a victim. He's been devastated by the loss of his mother and his brother, and then having to watch his father sit through a trial for their deaths. I mean, I'm certain is the absolute worst thing that could happen to anyone. And so it's hard for a lot of people to find Buster as a particularly sympathetic figure. And I'm not suggesting that you have sympathy for Buster. Buster is what he is. I hope that at some point he will emerge from this experience stronger and having done some real personal inventory and some personal insight. And I hope that that will he will find it to be an experience that he can look back on and say, that was incredibly painful, but I also experienced a lot of growth from it. Only Buster can decide that. And I'm not going to pass judgment either way. All I'm going to say is he is a victim. His name has been bandied about in connection with Stephen Smith, who was a young gay man that Buster went to high school with, and who died and who everyone believes was murdered. Early on in Stephen Smith's case, there was word in the community that perhaps the Murdaughs were involved. And I think that a lot of people have jumped to the conclusion that Buster was somehow involved. I know that that is an ongoing investigation. What we do know is that information that was discovered during the investigation into Paul and Maggie Murdaugh's deaths led the police to reopen Stephen Smith's case. We do not know what the outcome of that is, or if there is an outcome. We know that it's still under investigation. We also know that they have reopened Gloria Satterfield's investigation into Gloria Satterfield's death and have suggested that they may exhume her body. So there's much, much more going on with the Murdaughs. I can't say whether or not at this point Buster was involved in any of those things. But what I can say is that as of today, he is a victim, and it is incredibly disrespectful for the media or people who are passing as media to be harassing him to the point of taking pictures of him inside his home through the blinds. So I just hope that we're all the kind of people, and I'm confident of this because I know y'all, and we've been together a while, and I am confident that I can say that I think we are going to give him grace until the facts lead us otherwise. So for now, I think the guy needs some grace, and he needs some time to heal and get back on his feet, and we'll see where this case goes and where life takes Buster. But for now, I am confident that we are not the ones who are perpetrating those kinds of stories. So now we know that someone has been arrested in the Dylan Rounds case. And I think his family are incredibly relieved, at least, that someone has been arrested, but his body has not been located. We've had many conversations over the episodes that no body cases are hard. You're in the same situation with Anna Walsh down in Florida. And we know that her husband, there is a lot of indication that her husband was responsible for her death. And I think that is a pretty strong circumstantial case without her body. But Dylan Rounds, a little less secure on that one. So I think everyone is sort of keeping their fingers crossed that as the winter weather passes and spring gets here, that there'll be more opportunities. And now that they have, I think his last name is Brenner, in custody, hopefully they'll be able to apply a little pressure and maybe get him to tell them where the body is, because I think that would be a huge relief to Dylan's family and would also go a long way toward the prosecuting his murder. So now let's talk Vallow. As you all know, I get to sort of unload all the most recent developments for the first half hour, and then we're gonna take your questions. So before we open it up to questions, I just want to first of all, please, if you have not subscribed, please do. We have 238 people in chat, so I hope we'll have 238 likes today. I want to encourage you for a number of reasons to subscribe. First of all, we're 27 subscriptions away from hitting the 5,000 mark, which is amazing. And also because the Vallow case is coming up now in about, well, they're going to start jury selection in about 2 weeks. So when that happens, the judge has said no cameras in the courtroom. There is not going to be a live stream. There is going to be a closed circuit stream that will happen between Ada County and Madison County so that the citizens in Fremont and Madison County can see the trial. But they will have to go to the Madison County Courthouse and watch it live streamed. There's also going to be a live stream for overflow seating within the Ada County Courthouse here in Boise. There is no special provision being made for media, and there is no way to get those recordings. There is a way to get audio recordings of the trial as it goes forward. Right now, the court is charging for those, and it is going to be about $125 a day. So stay tuned because we're going to be talking about how y'all can help with that. I've got some messages out to a couple of other creators, inviting them to get involved with me to start a GoFundMe so that we can purchase those as they come out and release them free to the public. Because I'm pretty mad at the court and the way they're handling this. To suggest that you've got to fork out $125 a day in order to have access to those recordings, to me, is outrageous. So I'm hoping that we can come together as a true crime community, that we can come up with the money to fund those recording releases and then put them out for free, because I think that's the way to get around the court making a bunch of money off of the recordings of this case. So that's just me. And if you don't want to do that, I get it. You're not under any obligation to do that, but look for more information, because I'm going to invite a couple of other creators and their followers to join me. And then hopefully we'll just be able to put that information out for whoever wants it, without people having to pay $125 a day. That works out to about $4,000 to $5,000 total, depending on the length of the trial, how many days it goes. But presuming it goes 6 weeks, that's 30 trial days, and so that works out to not quite $4,000. So just look for more information on that as we go along, because I really would like to stick it to the court just a little bit for this court being so ridiculous about this. As we saw in the Murdaugh case, it is absolutely possible to televise a trial in a really professional way, in a way that is respectful, and still be able to allow the public to assure that their elected officials are doing their jobs. So I'll be getting some more information out probably early next week on that. We have heard repeated rumors. I have heard repeated rumors about potential settlement negotiations between Lori and the state. And I have heard, oh, sorry, I was just trying to watch the chat at the same time. And I've heard some pretty specific things about the negotiations that led me to believe that what I was hearing was accurate. But I've also seen, in anybody who's looked at the court docket or the court database has also seen that they've filed somewhere upwards of 140 subpoenas. Now, in general, and I'm not as familiar with the procedural rules in Idaho as I am in Oregon and Arizona, where I practiced. But in general, lawyers have a certain number of subpoenas that they can issue. But if you're going to do these mass subpoenas, they have to be signed by a court clerk sometimes. They have to be filed with the court nonetheless. And they decided that they were going to seal those subpoenas. And that makes a certain amount of sense because they contain addresses and phone numbers and identities of witnesses that you may really not want to have out there in such a high visibility case. So it makes some sense. We don't know who was subpoenaed, but we know that they have filed in excess of 140 subpoenas. That's 140 witnesses of some form or another, or it could be, it's unlikely at this point that they are subpoena ducis tecum, which is give me the documents and you don't have to show up. Ducis tecum is with documents or records. So what usually is sort of a process that you use when you're trying to get some discovery, particularly if they're records like hospital records or police records or those sort of things that are school records, things that are kept in the ordinary course of business. So I think what you're going to see is, since we're seeing all these subpoenas and where the clock is ticking, we're getting much closer to jury selection starting. If I had to guess, I would say that the plea negotiations have broken down, because I don't think I don't think we're going to see those. I don't know that we would be seeing quite so many subpoenas if we weren't full steam ahead for court. That's one of the reasons I want to encourage everyone to subscribe if you haven't. I'd love to hit the 5,000 mark this week, so 27 more people get 27 more people to subscribe. But the biggest reason is because we know there aren't going to be any cameras in the courtroom. People are going to have to put in a lot of effort to get into the courtroom. In order to get on into the courtroom, you are going to have to, every day, you are going to have to request an invitation or a reservation for the following day. You can only do it one day ahead. So people are going to have to make a real concerted effort to get their reservation in for the following day. So I think in requiring people to kind of jump through those hoops, they're sort of hoping that people are going to get deterred by that and maybe think, oh, it's too much trouble, I'm not going to do that. It's not too much trouble for me, and I'm going to be doing it, and I'm going to be in the courtroom as much as I possibly can. One of our great followers is going to help me out being in the courtroom because I'm going to be gone for a week in May for my daughter's wedding. But other than that, I will be in the courtroom, and I will be tweeting out from the courtroom updates, and I will be doing YouTube shorts at the breaks. So if you want to know what's going on in the courtroom, you need to be a subscriber, and you need to hit that notification bell so that you get notified when I post new content. So I appreciate you subscribing. I appreciate you being here this evening and being with us when we do have the opportunity to go live. And so I hope that you're all going to be with me on this very interesting ride. So, Vallow, we know that the judge has said no cameras, no audio recording other than the court recording system, which will be made available for a fee. And we know that the trial is probably going to take somewhere around 6 weeks. I doubt it's going to take the full 10 weeks that they predicted, because the cases are severed and they're only going to be trying Lori. But we don't know if she is found guilty. We still have a penalty phase, and that could take a couple more weeks for the penalty to be submitted to the jury and the jury to make a decision whether she gets death or life in prison. So it's time for questions. So I'm sure our mods have been marking questions, but if you haven't posted your question, please do. I want to thank Zelda, who asked me about my husband's back surgery. For those of you who aren't aware, he had some major reconstruction on his spine. One of the downfalls of having flown high performance fighter airplanes for all those years is that it sort of treats your spine like an accordion, and it flexes back and forth, and over time it wears out. So he has had reconstructive surgery. Y'all, he looks, if you look at the x-rays, he looks like he's got the Eiffel Tower in his back. He's got an erector set along his spine. They've literally created a whole new structure to hold his spine. It has been just over a year since he had that surgery, and it is a long, slow recovery. He's doing much better. So thank you, Zelda, for asking. He's making some really great progress with his physical therapy, but it's just a long, slow process. And so he's doing a lot better, and still has mobility issues, but improving every day. So, hi, Lee here. Thank you so much, Lee, for your donation. I want to remind everybody that every time you hit that super chat button, all of those donations go directly to our moderators. And I can tell you that it helps them out a lot. At the end of the month, I tally them all up and I split it in half and send each one of them a check. So thank you so much, because I know that it does help them out an awful lot. And I appreciate those who have the ability to be generous. One other thing, somebody asked me why I wasn't signed up on Buy Me a Coffee. And so I am signed up on Buy Me a Coffee. So anybody who wants to buy me a coffee, the link is in our show notes. And those of you who know me know I do love my coffee. So Lee here, if she waives her right to a speedy trial, will the cases be joined again? Yes, I anticipate if she were to waive her right to speedy trial, the judge would rejoin the cases. But I don't expect that she's going to do that. She has been absolutely adamant that she wasn't going to do it. I think if she was going to, she would have done it by now. So I think we're going to have a trial go ahead in a couple of weeks. And I think it will be really interesting to see how that trial goes. I also have every reason to think that she believes that she is going to be exonerated. She is going to be found innocent. I think that she still believes that this is a trial that God has sent her, and that that God is going to deliver her from this horrible trial. So, Rose M. I wonder if Lori Daybell will take the stand to testify. I would think not. I could be wrong. I mean, let's remember with Murdaugh, it is the client's absolute right to decide whether or not to take the stand. It is not a decision that anyone else can make, and it is not something that Lori's attorneys can prohibit her from doing. There's no way that they can say, Your Honor, you can't let her testify. So she could choose to testify. I think Lori has been pretty good about taking the advice of her lawyers. I think one of the reasons why she has refused to waive her speedy trial right is because her original lawyer told her not to. And so I think that she will follow the advice of her lawyers and not testify. But I could be wrong. I could be wrong. She could get on the stand and say all the things that that God that God is putting words in her mouth, or that God is inspiring her to say. I don't know. She's a very hard one to predict. I think anytime that you have somebody who has some serious mental health issues, I think that it's hard to predict what they're going to do. Much more difficult than somebody who's maybe doesn't have those kind of profound mental health issues. Because there's no question she's competent, but competency and you can be mentally ill and still be competent. Because to get to competency is a lower bar to jump over. And so it's perfectly possible for somebody to have a serious mental health diagnosis and still be competent to stand trial. Hi, Eleni. Thanks for joining us. Do I think the late disclosed evidence will be excluded? Yes, I do. I think that Judge Boyce kind of telegraphed that when he pointed out to the state that they had it was late, that the order said that the discovery was to be done prior to February 27th, and they produced it on February 27th at about 4:30 in the afternoon. And the judge was very clear that that was late and that they should have paid better attention to their deadlines. So that led me to telegraphed, I think, and led me to believe that he will exclude it, as he should, because it was outrageous that they are turning up this kind of evidence this is late in the case. Kathleen, what effect do you think Lori's alibi statement will have on the jury? Well, that's a good question. And so the mechanics of trial is that Lori's alibi statement, the one that is in the court file, is not necessarily going to be presented to the jury. But the defense was required to communicate to the prosecution that they intended to offer an alibi. I just reading between the lines of the filing, I don't particularly think that either of her lawyers puts much stock in that alibi, but they are required to file that in notice of intent to raise an alibi. And so I don't know how much weight that's really going to have with the jury. The jury really is the jury is the finder of fact. They're the ones who determine what's believable and what's not, and they decide what weight to give any particular piece of evidence. So they're not going to see that notice. They'll probably see that information because she's adamant that she didn't do anything wrong and that it was all somebody else's fault, namely her dead brother. So I don't know that it's going to have a huge amount of weight at all. Good question. And Kathleen, thank you so much for your continued support. You're a very faithful viewer and great support to our team. So thank you. Will the late evidence be able to be used in Chad's case since it will be later? This is a good question, and the answer is yes. As long as, the very reason that Chad's case was set over was because they needed to have the ability to investigate all of that newly presented discovery. The judge couldn't do that in Lori's case because she hasn't waived her right to speedy trial. Chad has, so the judge could give him extra time to investigate that. But if he has extra time to investigate it, then the state's going to be free to bring it in. So yeah, it will come in his case. And that's a very interesting distinction because there could be information newly discovered in that newly discovered DNA or in some of those other newly disclosed pieces of discovery that could be helpful to him or could hurt him. And we won't see those in Lori's case. Kavita Deva? Please explain what is a speedy trial and what is the benefits of having a speedy trial. Sure. The U.S. Constitution, the Sixth Amendment of the U.S. Constitution ensures that that every defendant has the right to a speedy and public trial, meaning that it has to be done in the bright light of day in public, and that a person cannot languish in jail for long periods of time without having been brought to trial. So many states have a statutory period of time that during which somebody has to be brought to trial. In Idaho, it's 6 months. So a person has to be brought to trial within 6 months, or their case has to be dismissed unless they waive their right to a speedy trial. So in Lori's case, she has never waived that right. Now, under the United States Constitution, the constitutional law, the case law, indicates that it's somewhere around a year. But in Idaho, we have this statute that supersedes that underlying U.S. Supreme Court case law. So the statute does say that the statute of limitations is told during certain circumstances. So during the time that she was declared incompetent and her case was suspended, during that time that her case was suspended, that those days that went toward her speedy trial didn't run. So that whole period of time, let's remember, first of all, that she actually wasn't indicted until after her commitment was up. And then it was 6 months from the day of her indictment. Now, the prosecution came back and said, we need extra time. And the judge granted it, saying that there was good cause. And there was a period of about 4 to 6 weeks late last year when her attorneys asked to have her reevaluated, her mental health reevaluated. That didn't count either. So according to everyone's count, the April trial date is about 40 to 42 days, depending on who's counting, over her speedy trial deadline. The judge has found good cause because this case has been, the venue's been changed and they're having to work with Ada County to get the trial dates done. So when they vacated the January date, which was within her speedy trial dates, then the court was at the mercy of Ada County to get it rescheduled. So the benefit of having a speedy trial, well, the benefit in general is holding the state's feet to the fire, making sure it is not uncommon. And I know y'all have heard Scott Reich say this before, you don't bring the charges until you're ready to try the case. And I think that's true, if you're a prosecutor, but prosecutors don't always have that luxury. And so often what happens is they feel that they have enough evidence to meet the probable cause standard, to meet the grand jury or the preliminary hearing, and they continue to investigate the case as it goes along. The sooner that you can set your trial date, the more likely it is that you're holding the prosecution's feet to the fire, and the more likely they may not be able to investigate to the extent that they can bring the case. And you may be forcing them into a plea that you might not otherwise have gotten because of the state of their investigations. So there is that benefit. And I think that there are a lot of lawyers who feel that the sooner you can get your case to trial, the more likely it is the prosecution's not going to be ready. And either they're going to cut you a sweet deal, or you're going to be able to get a not guilty because they're not able to prove their case beyond a reasonable doubt. So, good question. Hazelnut. Question. Hi, Lori. You may have answered this before, but I missed it if you did. Is this the first death penalty case that Lindsay Blake and Rob Wood have ever tried? Yes. Yes, it is. It is the first death penalty case for Judge Boyce, the first one for both Lindsay Blake and Rob Wood. That's one of the reasons they brought in Rachel Smith, because she has had experience defending death penalty cases. The attorneys for Lori are both death penalty qualified and have both tried death penalty cases before. They're actually both qualified, I believe, to be lead counsel. I know for certain Jim Archibald is. So they are qualified and experienced, but the other side is not. So good question. And I think it shows. I think that they've committed some real missteps. I have said from the very beginning, the biggest misstep they committed was not hiring a dedicated discovery clerk for this case, because people will go on about how many terabytes of information there are and how voluminous the discovery is in this case. Well, you need to have somebody whose full-time job is to manage that discovery and to manage it because it's continuing to come in, and to reach out to law enforcement agencies and be sure that you have it all. That doesn't happen automatically if you're just sitting there twiddling your thumbs. So I think that was a real big mistake on their part. Gritty Gret. Is Mark Means prevented from communicating with Lori even as a, quote, friend? I believe so. About the time that he was removed from the case because of the conflict, Jim Archibald filed a motion with the court asking the court in particular to order that Means have no contact with Lori. And I believe that has been going forward. I think there are a couple of other reasons why he would not want to have contact with her. One is that we all believe that he has been being investigated by the Idaho State Bar. I'm unfortunately, like many other things in Idaho, the Idaho State Bar's investigations are all done confidentially and in secret. In a lot of other states, if an attorney has even a complaint, even if it's not a resolved, adjudicated complaint, even if there is an open ethics or malpractice complaint, that is public record. For example, in Oregon, at any point, if you are considering hiring a lawyer, you can call the Oregon State Bar and ask, do they have any open complaints? Have they had any adjudicated complaints? What is the status of their bar membership? And that is public record, and the bar staff will tell you. Not so in Idaho. In Idaho, it's all being done in secret, and you do not know whether or not there is a pending complaint, and you will not know unless and until there is a decision that comes out against the lawyer. If the bar investigates and says there's nothing here and exonerates the lawyer, that never gets released. So I happen to think that's not a great system, but so we have every reason to believe that the Idaho State Bar is investigating Mark Means, and that at some point that will wind its way through and get adjudicated. It would be very risky for him to communicate with Lori if there is an ongoing complaint open. What we do know about him is the only thing we know about him comes from his LinkedIn profile, and that says that he is an attorney and professor in Missouri. So it appears that he's teaching. We don't know what he's teaching or at what level. And he is still listed on his LinkedIn profile as an attorney. I do not know his status with the Missouri Bar. I have not taken the time to inquire to the Missouri Bar whether he's in good standing there. I know one time he was trying to get into the Missouri Bar, and it would be very difficult to get into another bar if you had a pending disciplinary complaint in a different state, because the states do communicate with one another. So if you apply, say I applied for the Idaho Bar would immediately go to Arizona and Idaho and Oregon and ask in both states whether I had any disciplinary actions at all, whether they were pending or whether they had been closed. So I would suspect that if he's trying to get into the Missouri bar, it might have been difficult for him if there is that, as we suspect, a pending case in Idaho. So I really doubt that he is communicating, and I think that that would certainly raise yet more complaints from Lori's current attorneys if he were to do that. Good question, though, because I think he's had a lot of influence on Lori during the time that he represented her. Oh, hi, Score. Question: are safe deposit boxes considered for search with search warrants? And if so, how often does it happen in your experience? They absolutely are. And generally, when they send a search warrant, let's say they send a search warrant to Wells Fargo Bank, it would say, I want you to tell me whether this particular person has any account of any kind with Wells Fargo Bank, including, and they will list all those things, and they will include safe deposit boxes. And if there is a search warrant to search a safe deposit box and the defense doesn't ask to have that search warrant quashed, then the bank will open the box. So it absolutely, they are subject to search. Flashback. Question: are you going to hold out any juicy tidbits you may learn along the way for the book, or will you let us know as you discover them? Good question. I am going to share as much as I can with you as long as it is confirmed. If there are things that I need to check out before I make them public, then I won't do that until I have been able to corroborate the things that are in the book. So subject to fact checking, if I hear anything juicy, you'll hear it too, because really the book for me is a way to synthesize all of those things and to try and to make sense out of it. So one juicy tidbit might not be all that pivotal to the book. You all might find it really interesting and it might be a lot of fun to talk about it. But in the big, I really want the big picture so that I can understand how all of these things fit together. Because the thing that has always fascinated me about this case is the layers of emotion and influence and the factors that have gone into this from the beginning. So that's the part I want to put together so that we can all understand how it happened, maybe begin to understand why, and certainly be able to say, we're going to treat this as a cautionary tale. So I promise I won't be holding out on you. Amy in Boston. Hi, beautiful Lori. Aw, thank you. Question. Uh-oh. Can I have my question back? And then you can buy me a coffee. Can I have Amy's question back? Thank you, my darling moderators. Will the video of Vallow proceedings be available after the verdict? I don't think so. I think the only thing that is going to be available after the verdict is going to be audio. I do not believe there's going to be video available. I don't even know if it's going to be recorded video. I think it is going to be closed circuit video that'll be transmitted to the satellite viewing areas like the overflow room at Ada County and the satellite viewing area in Madison. But I don't know that it's even going to be recorded and preserved. I think it's going to be a live stream, and that's going to be the end of it. So unfortunately, there will not be video available after the proceedings unless something changes. Chandra Cloud. Hey, greetings from Oregon. I was just in Oregon. I was in Portland. If Lori's found guilty, do you think Chad will be more likely to take a plea deal? Interesting question. I think perhaps the reason I say that is because once she's adjudicated, then she can be called as a witness against him. So I think that's dangerous. And it has the potential for making it much more difficult for him. So it may be more likely that he would take a plea, particularly if they take the death penalty off the table, which I think they will. I think the death penalty has always been a bargaining chip. So what would be really interesting is if Lori gets convicted and the jury orders the death penalty, and then Chad takes a deal and the death penalty is off the table for him. That would be pretty interesting. Kathleen Smith. Oh, don't forget to set your clocks forward if you live somewhere that uses daylight savings time. I'll be a zombie tomorrow, but please don't tell the Daybells. You know, that was one of the many things I loved about living in Arizona was the fact that we didn't switch. And I'm one of those grumpy cats when it comes to going from daylight savings and back and forth. And I especially don't like losing that hour. So, well, speaking of an hour, we're coming up on the hour. And so I'm going to take a couple more questions and then we're going to close out. Please remember, I go through all your questions. So if you post questions down below, I answer them. I didn't get to quite as many of Wednesdays as I usually do because I was headed out of town, but I will go back through all of the questions and comments tomorrow. And I go through them, and I also browse the chat and look for questions that I might have missed. So, and you can always email me. The email is info@thelorivallowstory.com. And you can definitely email me to ask questions. Retired RN 43. Question. Maybe this should be obvious, but where will Lori be during her trial? Will she be in Ada County in the courthouse? She will be. She will be physically present in the courtroom during the trial. She will be held at the Ada County jail while the trial is going on, and she will be transported from the Ada County jail to the courthouse every morning for trial. She will be wearing street clothes, and but she likely will have restraint mechanisms on. Usually there's kind of a leg splint they wear. Sometimes they wear a stun vest under their under their clothes. It just depends on the sheriff's department and what security they think is appropriate within the courthouse. But she will be there in person and in the flesh. Nikki Fife. Question. Although cameras are not being allowed for Lori, could that change for Chad? I suppose it could change, although Judge Boyce is going to be hearing both cases, and as it stands right now, he has decided no cameras in the courtroom. So I don't really. I thought there might be a chance that once all of the pretrial stuff was over, that he would relent and allow the cameras in the courtroom for the trial because of the issue that has been raised by so many of the family members that they're not able to travel and spend 3 months here for a trial. So I was disappointed that he didn't revisit that. He could always revisit it, but I wouldn't anticipate it at this point, particularly with Lori's trial going forward with no cameras. Beachy Broad. Question. Can the Idaho AG take over the Vallow dumbbell case? Not unless the prosecutors ask them to step in. If you remember, early on in this case, when the investigation was still going on into Tammy Daybell's death, and the children's bodies hadn't been found in Fremont County yet, Fremont County District Attorney at the time, whose name is Marsha Murdaugh, asked the AG to come in and take over the Tammy Daybell case because she didn't feel that Fremont County had the resources to be able to investigate the case. When Lindsay Blake, Marsha decided not to run for re-election because of some health issues. And when Lindsay Blake ran and won the seat, then she asked the AG to return the case to Fremont County. So the only way the AG can step in is if the prosecutor asks them to. Zelda. I'll bet you a pound of Starbucks that Lori Daybell will take the stand because she's got a message for the world. You know, you may be right, but I'll take that bet because I think she is going to follow the advice of her attorneys. So, okay, it's public. A pound of Starbucks on that, and I'm going to bet she does not take the stand, but you could be right. Let's take one last question, and we're going to wrap up for the evening. I will be back here on Wednesday at our usually scheduled time. And at that point, I hope I'll have more information for you on a GoFundMe campaign for the audio recordings for the trial. And hopefully we'll get that launched and off the ground before the trial starts. So I will just want to say thanks again. Hey, Speakeasy Lounge. Hey, y'all, if you have not joined Speakeasy Lounge on YouTube for her music program, please do. It's a great show and I enjoy it a lot. Has anyone seen any social media for the judge? I'm curious if he ever reads or watches people's reactions to everything that is going on. That's a good question. You know, early on, they all got in trouble for having a county employees Facebook group. If he is on social media, it is way under the radar and under an alias. I don't think there's any way we'd ever find out if he is. He has said that he has gone out of his way not to read news articles, he's not watching any of the TV coverage, the HBO special. He's trying to avoid information about the case, even though he will not be the finder of fact, the jury will. He's still made an effort not to be involved in the case. So, he said that during some of the hearings. So, well, that's going to wrap it up for us tonight. Please post questions if I didn't get to them, either in our comments or email me. Thanks again for joining me. We've got 400 people in chat. I know you got a lot of ways that you could spend your Saturday night. It's really gratifying to know that y'all missed me last night. And I hope that you have a great weekend, and we'll all get back together on Wednesday. Thank you so much, Bama Girl 55. You are more than welcome. It was our honor to serve, both of us. So thank you so much for joining us. Thanks for all of your donations tonight for our mods. You were incredibly generous, and we appreciate it. Thanks for the coffee. Zelda, you're on. And I'll talk to you all on Wednesday.